My name is Ashley Roybal-Reid, and I am a litigation associate here at Farella. I work on primarily intellectual property matters as well as a few others, and have litigated a few issues related to cannabis IP in the last couple of years. Nate?
Hi, I'm Nate Garhart, and my practice focuses on trademark, copyright, and advertising, as well as online policies, including privacy policies and terms of use and the like. In the trademark and copyright realm, I counsel clients and work with them on protecting and registering their properties. So as the slide says, as the title says, we're jumping into IP issues. So we have a just quick question, a poll. What IP issues do you think are going to be important to cannabis businesses? And if you could just click to answer. We'll give it about 10 more seconds. All right, so yes, that's exactly right. It truly is all of the above, and that's what we're going to cover today, is all of the above: trademark, copyright, patent, and trade secret issues.
So within those four areas, we'll give kind of a broad overview. First is trademark. Trademark is your brand. It is your name, words, logos, sounds, even smells that identify your brand. And it can be the way those words are presented as well. Copyright is going to be any original work of authorship. So usually a little bit more longer and more developed than trademark, but it can be books, music, plays, photos, articles, any number of things where you've put in some work to author work. Patents is probably the most well-known of IP law, at least among the lay public. It covers novel, useful inventions or processes. So useful is the key word. It's got to be something that has a function, not just exists and has been invented. And then trade secret can cover things that could be subject to copyright or patent under other circumstances, but generally is valuable, protected, confidential information. And as I said, can cover a pretty wide variety of things that meet that definition.
So why do you want to protect your IP? Well, there are a number of reasons. And, at its core, it's really protecting your core business. The intellectual property often represents a lot of the value of the business, and it's important to protect that. Additionally, it gives you a stronger negotiating leverage when you're in discussions with other entities. If they have a harder time doing what they want to do without your protected assets, then you're going to be in a better position to negotiate the best terms in that relationship. Additionally, you can block potential competition. If you don't protect your IP, there is little to stop another party from using your same IP to do the same thing. And so protecting your intellectual property can help block those competitors. And then finally, protecting your IP builds value. Your intellectual property is counted as an asset in valuation, and if it's protected, it's more likely to hold value. Additionally, investors, and to the extent you get into banking relationships, lenders both like to see protected IP. They like to see trademark registrations, copyright registrations, patents, and evidence of protection of trade secrets. So all of its value has significant value in your business. So we're going to jump right into trademarks. And we actually take a good bit of time on trademarks because it really is at the forefront of any business, because it's not only the name of the business, but it's truly the brand itself. It is what your business stands for. It represents what your business stands for. So when you choose your name, the first thing you have to think about is distinctiveness. A lot of people would like to choose names that quickly tell the public what they do. Such names, while useful from a marketing perspective and getting the public to understand what you do, are less protectable than names that are more distinctive. So you have to balance where you want to be on the distinctiveness spectrum. So if you look to the farthest left category, the fanciful marks, that's the most protectable. And as you go to the right, it becomes less protectable. Those first three categories are kind of the sweet spot where you really want to land to have your mark as protectable as possible. So what's a fanciful trademark? It's a word that didn't exist until it was created by the owner of the trademark. So the classic example is Kodak. Eastman, when forming the Kodak company, made up the name, basically came up with it himself, thought it sounded good, and named his company Kodak. That word had no meaning whatsoever until he started the company. Now it's become a little less famous, of course, because film cameras aren't what they once were, and cameras in general aren't what they once were as far as consumer products. But it gained great fame, and just about anybody would know the term Kodak in connection with cameras. So moving to the right, what's an arbitrary mark? It's an existing mark, an existing word that you use for something that's not necessarily, actually isn't connected to that word. So tilt for a cannabis company. The word tilt has lots of meaning, but it doesn't have any meaning in regard to a given cannabis company. The classic example of an arbitrary mark would be Apple for computers. Apple certainly has meaning, but until it was used by Apple Inc. for computers, it had no meaning in the computer industry. Suggestive marks are a really good direction to go because they give you some of that telling the consumer what your company is about, but they are still very protectable. So they tend to be terms that are created in a way. Here we have three examples of terms that are created from at least parts of existing words. So Curaleaf for a company that might have products and services related to medical marijuana. You can see how that gives you some sense of what's going on with it, but Curaleaf is certainly not a word and certainly doesn't have any actual meaning in the language. So it's really very protectable, and yet does give certain connotations that help consumers understand what your goods and services are likely to be. The next category is descriptive marks. Descriptive marks are not protectable until you show that they have acquired distinctiveness. And they acquire distinctiveness through length of use, basically. The longer you use them, the more likely you can say they have acquired distinctiveness. So an example of a descriptive mark would be Weed Maps in connection with a cannabis company that helps identify where you can get certain products. That mark is likely not registrable until it can be shown that it has acquired distinctiveness. But they are protectable at that point, and just because a mark is descriptive doesn't mean you shouldn't try to protect it. The last category is words that are not protectable as trademarks, and they're generic terms. Now you have terms that are automatically generic, like Apple for, say, fruit stand, or apples or fruit products. That term would definitely be generic for those goods and services. And then marks can become generic. So aspirin was once a trademark of the Bayer Corporation for its acetylsalicylic acid product. And Bayer was the only entity that offered aspirin for that product named aspirin. Over a long period, consumers started calling all acetylsalicylic acids products aspirin, and Bayer failed to enforce against them. And so once other companies started referring to their products as aspirin, Bayer started to lose rights. And it ended up, there was a determination at some point that Bayer had lost the rights, and it wasn't able to enforce its trademark rights against any third parties using the mark. Now note that that's true in the United States. It's not true in Canada, for example. So if you're in Canada and you buy aspirin, you are buying a Bayer product. While in the United States, as you know, there are many different brands that offer what they describe as aspirin products. Interesting side note on that is Xerox. So Xerox makes photocopy equipment, and in the 70s and 80s, the term Xerox started to be used kind of like aspirin. People started to refer to everybody's products in the photocopy industry as Xerox products. Is that a Xerox machine? Is that can you make a Xerox of this for me? And Xerox got concerned it was going to lose rights in its trademark. So it undertook a very large ad campaign where it took out full-page ads in magazines and newspapers that said, when you use Xerox the way you use aspirin, we get a headache. And through their efforts, the term Xerox stopped being used in a generic sense, and they retained their rights, and they brought it back from the precipice. So the point is, when you have rights in a mark, you need to make sure that you're protecting those rights through not only registration, but making sure your trademarks are being used correctly.
So when you're selecting a mark, there's a few things to consider. First one is distinctiveness, which Nate just talked about at length. There's also the existence of third-party marks that are similar to or might relate to the mark you're considering. For obvious reasons, even outside of IP law, you don't want a mark that's really similar to one created by a competitor or by someone who you think makes a subpar product in particular. And someone who has a third-party mark that's similar to the one that you're trying to register can oppose your ability to register that mark. And that they would do so based on a likelihood of confusion. And that's kind of the fundamental consideration when looking at whether or not your mark is too similar to marks that are out there. And there's two elements of that. The first is the similarity of the marks. So how similar is the mark that you are registering or trying to register to marks that are out there on the market? And the second is similarity of goods. So to go back to the Apple example, you couldn't register an Apple trademark for a computer or probably something similar to a computer, a digital device of some kind. But there is another company out there called Apple One, which has a registered trademark for employment services. So their services are different enough that you're not likely to confuse their products with ones that are being offered by Apple Computer. So those two factors in assessing similarity are really critical in determining whether or not your mark is registrable and whether or not you can oppose someone else's mark that appears to be similar to yours.
So when you're thinking about marks and you're looking, at your distinctiveness and you think you've come up with a distinctive mark, how do you go about checking out the situation with third-party marks? Well, we do that through searching. There are a couple of different kinds of searching. First of all, I have a picture here of the trademark office's database search screen. And there's always the Google search, right? Because we should note that in the United States, you get trademark rights just from using a mark, and there are reasons to register, and we'll talk more about that. But the bottom line is you have to be concerned about registered marks and unregistered marks. So you could check out the USPTO site, the trademark office site. You could check out Google. But the problem with that is you have to look at not just identical marks, but also even similar marks used for similar goods and services. So that's hard to do through these databases. As trademark practitioners, we have access to different kinds of searching that enable that sort of searching to find not only identical hits, but also similar marks used for similar goods and services. Additionally, we can look much broader than just the USPTO site and can look at state registrations, can look at international registrations, can really get a feel for the risk associated with a mark. That said, we do searching in two steps. We start with preliminary searching that looks at registered marks. We call this a knockout search. We basically just want to see, is there anything that's just such a clear problem that's been registered or applied for that we can quickly determine whether it's worth it to spend more time and money on this mark. Once we determine that a mark is not knocked out, we jump into comprehensive searching, which is deeper searching, looks at all kinds of databases and gets a deeper understanding of the risk associated with a given mark. Of course, preliminary searching is a lot cheaper, and that's why we do it first, to see if it's worth it to spend the money on comprehensive searching. But we do undertake both levels of searching with most marks when people are choosing a brand to really make sure the client understands the level of risk involved with a given mark.
So when you're naming your product, we talked about looking at similarly named products out there. And some people want to have a name that's similar to other products. So looking at these, how many of you think, well, that's satire, it's parody, that's got to be okay? Mark, we have a poll for this. So how many of you think that these are permissible and these are okay uses of or parodies? All right, Mario,
We'll give it about 10 more seconds. Oh, okay. So it looks like most people did agree that this probably is not the best direction to go. And I definitely agree with you all. At the end of the day, these are going to be problematic, and Hershey is going to take significant issue with these. The bottom line is there are a couple of issues with it. First of all, there's a question of, is this parody? I hear a lot, well, parody is protected free expression. And that's true to some degree. But when you look at this, there's actually a distinction in the courts, and things change. But there was a distinction, and I think it's a very relevant one, between parody and satire. And what courts said for a while was that, look, parody is when you use somebody's property to make fun of them, to poke fun at that company. Satire, on the other hand, is when you use their property for other purposes. And if you're not poking fun at them, if you're not commenting on them, then it's not protected. It's only when you're using their property to make a statement about the property owner. And here, arguably, you're not really commenting on Hershey's. It's just kind of a clever pun to use these famous names. And that's the second point. These are famous marks, and famous marks, Mr. Goodbar and Reese's, for chocolate products, are certainly known all over the United States, probably around the world, in connection with their chocolate bar products. And so in that case, a trademark owner gets broader rights, and this would actually amount to tarnishment of those rights, which is actionable under the law. So they get an additional hammer to throw at you when they're dealing with somebody using their property in connection with goods and services that are not theirs. So even though nobody would probably think that Hershey's released these two candy bars, they could feel that way because the marks are famous. But moreover, it doesn't matter. Hershey's has these broad rights, whether there's confusion or not.
So how do you protect your trademarks? One of the things that you want to do is you want to register it where you can do so. And I know one of you had asked about this, how to avoid brand infringement by another company when they have legal products like dietary supplements and you have a cannabis product. And that's one of the challenges that arises for cannabis companies, is that federal registration is not available for recreational cannabis products. You can use it for hemp products or for various smoking accessories, but it is not available generally for CBD products. So as I said, you can register accessories for the most part, as long as they have a use that is not prohibited under federal law. You can also look at state registration. There are a number of states, 11 right now, that allow state-based registration. California is one of them. You can register a trademark under California law for products that in California are legal, including cannabis, and a number of people have done so. It can get a little expensive because you have to register in multiple states rather than a single state, but it has the benefit of providing you protection within that state and also creating kind of a history of use that may come in valuable both in other states and also later on if federal law changes and you do become able to register cannabis products. You now have a history with this brand that you evidenced by your registration.
And this begs the question of, well, I mentioned earlier that you don't have to register a mark, so why would you do so? Why would you spend the money? And first, Ashley's point that it gives you evidence of protection is important. Additionally, When you rely on use rights, your rights are geographically limited to where you have actually used the mark. So let's say you sold only in Mendocino County. In that case, your rights are likely to be limited to Mendocino County. Whereas if you have a California state registration, it gives you rights that cover the entire state of California. That's true at the federal level as well. If you only have use in California, let's say California and Nevada, your rights would be limited to California and Nevada. Whereas if you have a federal registration, you get what's called constructive nationwide use that would give you broader rights across the country. So a lot of value in the geographic reach of your protection. The other thing is the notice you get to use. And jumping to the last point, when you register a mark, you get to use the circle R. When you're relying on unregistered rights, you use the TM, the superscript TM. So just keep that in mind. Consumers tend to put a little more value, research has shown, into marks that are registered, into products that have the circle R. So there's certainly that value as well. So I just want to touch really quickly on international registration. Just like states, you have to go country by country for registration. You have to determine legality in each country, and you have to file an application separately in each country. There are different rules for each country, so you have to deal with all of that. There is a kind of blanket registration system called Madrid, under what's called the Madrid Protocol. And under that, you can register in more than one country at once. You basically extend your US registration to other countries. But there are significant reasons that can be problematic, not the least of which is that it's very difficult to get a federal registration at this point, and a federal registration here might not be available for you when there is availability of registration in different countries, Australia, for example, the EU potentially. So you can get registrations elsewhere. Finally, on international registrations, you really want to be thinking about, there's no reason to get a registration in another country unless you plan to be there at some point, or unless you fear that there could be counterfeits coming out of that country. So a lot of clients seek to register in China because a lot of counterfeits come out of China. And if they have a registration for the mark in China, it makes enforcement against those counterfeits more easily accessible. But if you want to discuss international registration further, please don't hesitate to reach out.
So here are a few examples of cannabis trademarks that are registered with the Federal Patent and Trademark Office. And again, you can't register a recreational cannabis product, but you can register things that are very similar, which gives you some level of protection. So there's two image marks here and two just word marks. Irie Buds covers clothing, which generally has cannabis related imagery on it. The Loot covers wellness products, lotions, and a number of hemp-based products. Stoner's Club covers rolling papers and smoking accessories. Curaleaf is interesting because their registration itself says, describes its products as smokers' articles, namely smoking pipes and oral smokeless vaporizers, tobacco storage boxes, tobacco grinders, none of the foregoing intended for use with cannabis. So I think they probably were concerned about getting in trouble there, and they specified in their registration that this is definitely not a cannabis product. But if you look at their website, it tells a little bit of a different story. They advertise a lot of dispensaries and other things. So you can register for products that are related to the products or to cannabis products. And generally, those registrations may be protectable depending on how legitimate that registration appears to be.
And you do keep in mind something like Curaleaf, and I'm certainly don't know all the facts involved, and it's always fact specific, but you have to be careful with your registrations. If you state that a product has no relation to cannabis, such as an edible, and you say that it doesn't contain any cannabis or something like that, and then it turns out that you offer products, true, that don't include cannabis, but you also offer products under the same mark that do include cannabis, that can be problematic. And so this isn't a get out of jail free card, if you will. This isn't a way to just, jump through a loophole and be able to register a mark that wouldn't otherwise be registrable. You really have to be careful with it. So we're going to move on to copyright. And what is copyright? Copyright is the type of intellectual property that protects original works of authorship. Now, those original works have to be fixed in a tangible medium of expression. That comes straight out of the Copyright Act. And what does that mean? What is fixed? Fixed means that it's not just ephemeral. It's not just going to disappear. The classic example of something that's not fixed is smoke signals. From what I understand, somebody could have basically written a novel and written's the wrong word, but created a novel and told the story using smoke signals. But because they're not fixed and because they disappear, such a story would not be protectable by copyright. And instead, it would take some kind of recording of that, whether it's filming or the like, to make it a story and a work that could be protected with copyright.
That being said, there are a lot of things that are subject to copyright, and these things are protected from the moment of their creation, not once they're registered. They are copyrighted from the moment they're created. So those include literary works, pictorial, graphic, and sculptural works, musical works, including lyrics, which can be copyrighted separately, movies, audiovisual works, dramatic works, pantomimes and choreographic works, as long as Nate mentioned earlier, they are fixed. So you can't just do a pantomime on the street, but you could do a pantomime by video, or you could write down the steps of your pantomime, and then that written work would be copyrightable. This slideshow is copyrighted, among other things. And architectural works are also protected by copyright. So what is not eligible? Copyright is pretty broad, but it does not cover concepts, ideas, procedures, processes, systems, methods of operations, principles, and discoveries. So you can register a written work that describes these things, but you can, or a video showing how to do something, but you cannot copyright your method of doing it. And the classic example of this would be a recipe. Most recipes, if not all, are generally not copyrightable. So this could come into play with edibles. You can register, of course, a trademark that you market the edibles under. You can also register a book displaying the recipe, in which you put the recipe in with a number of photos and you tell a story about it, or you compile the recipes together in a particular way, but you can't copyright the recipe itself. That's not protectable.
So with a thin copyright, the issue is that the measures, those kind of things from the recipe, the steps in doing it can't themselves be protected such that you could keep somebody else from publishing those same measures and steps. But the language that you use, to the extent that it's not just the steps themselves, but instead you, tell a story about how you learned to undertake that process or whatever, that can be protected. So it's a very thin protection that doesn't protect the process itself or the recipe itself, but instead only protects your expression that you've added in that recipe or process. So what does copyright give you? Copyright gives you a bundle of rights, these 5 different rights. And why is this important? We see this a lot in licensing. A lot of times you need to get certain rights in order to use somebody else's work, or you want to give others rights to use your work. And a lot of times in a license, I'll see something that says, the licensor hereby grants the licensee the right to use the work. That's that last bullet point. Well, the law doesn't say anything about copyright and use. I use the term use and use shorthand all the time for talking about these. But as far as a legal right, there is no legal right to use somebody else's work. So licenses need to call out the specific rights that you're offering or getting from the licensor. And so those could be different in different situations. You would give a distributor certainly a right to distribute your product, and to the extent that they're manufacturing it, a right to copy it. If your work is a website, say, you're going to give a third-party host or the like the right to display that copyrighted work, but you're not necessarily going to give all of these rights to any licensee. And if you're the licensee, you're not necessarily going to get or want all of these rights from any licensor. So they need to be called out individually rather than just being referred to as a use of the copyright.
So here's a few examples of copyrighted works that are cannabis related. So you have 2 books of recipes, which we discussed a little bit earlier, and the individual recipes in there. One is a recipe book that relates to wellness products. The other one is a recipe book that actually provides recipes for food and edibles. Neither of those are going to have recipes that are themselves copyrightable generally, but the books, the imagery in them, the way they're laid out, the collection of recipes as a whole is going to be subject to copyright. See, Bon Appetit might have a few issues with trademark, which we talked about earlier. You can imagine that Bon Appetit magazine might take exception to their name being used in this way, but it's a thin protection because Bon Appetit is also a commonly used phrase. So we'll see if that ends up being a battle, but those are both subject to copyright as written works, the books are. Then if you look at the bottom right, you see that is a page from Weed Maps. That page displays trademarks from a number of other entities that are sold by Weed Maps or through Weed Maps, or that are found through Weed Maps anyway. So those trademarks, of course, are not owned by Weed Maps, they're owned by others, and Weed Maps has simply put them on a page and displayed them in a particular way. But Weed Maps can still register a copyright for that page, for the way it's laid out and the way things are presented. Similarly, Facebook, you see this Facebook page, which is for a cannabis-related advocacy group. Of course, they don't own the layout of that page. Facebook owns the layout of that page. It's Facebook. It's a distinctive design. Everyone knows that's what a Facebook page looks like. So Facebook has copyrighted that layout. However, when you create a Facebook account, you agree that you maintain ownership of your copyrighted works that you post there, while granting a limited license to Facebook that allows them to display your work on the internet. So those photos are protected by copyright, as is that comic that's displayed on the page. Any work that's displayed on there is subject to copyright, most likely has not been registered, but is still a protected work owned by the author that created it. So that leads us to the next point, which is who is the person who owns the work? And as I said, generally it's the author, it's the person who created it. However, there are some exceptions. First one is where work is made for hire, the employer owns it. Nate's going to talk a little bit more about that in a minute. The other case is where there's an assignee. And just as with any other property, you can assign your intellectual property, including your copyrighted work, to someone else, either through sale or through a temporary assignment. And they then become the owner of the work and can enforce it and exercise their rights accordingly.
So what is a work made for hire? Work made for hire arises in 2 situations. The first is works that are created by employees. And it's specifically those works created by employees within the scope of the employee's employment. So if you hire a developer to develop certain software for you, and she develops that software, at that point, you as the employer own the software. Imagine though the case where you hire a secretary, and that secretary, unbeknownst to you, happens to have some development experience, and he says to you when you're talking about a new piece of software, hey, I can help with that. Here's some code I put together that could be useful to you, and he puts together some code and provides it to you. In that case, the secretary's role does not include software development. And so even though he is an employee, that work is outside of his scope of employment, and it would not be a work made for hire. So the employer would not own that work and would instead have to get it by assignment. So you have to look closely at your employees, but generally what your employees create for you within the scope of their employment is owned by the employer from the get-go. The employer basically steps into the shoes of author and is considered the author. The other situation is in connection with independent contractors. Copyright law speaks to this directly. The Copyright Act talks about independent contractors and works made for hire. And it says where you commission a work and it's agreed to in writing that it will be a work made for hire, it will be, but only in very limited circumstances. And the Copyright Act lays out those specific circumstances. The classic one is a film. And the idea with that was, look, if you're making a movie, you're going to have to hire a cameraman, you're going to have to hire a sound recorder, you're going to have to hire a scriptwriter. And at the end of the day, there really should be a mechanism where whoever is truly creating the film as a whole comes to own everything automatically because they truly are the author. So as long as everybody agrees to it in that situation and enters into written agreements identifying their work as works made for hire, the employer in that case that hires the independent contractors will own the work and will be the author of everybody's commissioned works. But again, it's only in these specific enumerated situations, and they're pretty limited. I said the classic example of a film. Another example is in map making. A third example would be forwards to books, things added to books, indexes created for books, that kind of thing. So again, they're enumerated situations and you have to be careful. It's actually rare that something will qualify as a work made for hire. In connection with that, I often see independent contractor agreements that include this language. They say that the contractor agrees that the work will be a work made for hire for copyright purposes, or if it's not deemed to be a work made for hire, that the contractor hereby assigns to the company all right, title, and interest in and to the product. So what do you think of this language? Margaret, if we could have the poll. Do you think this is a good idea? We're neck and neck. Let's give it another 10 seconds. All right, a bunch of people don't want to go on the record here. I don't blame you. So the bottom line is it's actually not a good idea. And the reason is one that's not clearly obvious and that you'd have to dig a little to find out. But, I definitely understand why people would say, hey, look, belt and suspenders, what's the problem? Well, the problem actually comes from employment law. And under employment law in California specifically, there is case law that says if you have a work made for hire agreement, if you have an independent contractor agreement, and you use the words work made for hire, then you could be subject to paying certain benefits to that individual, including workman's comp insurance, that kind of thing. And so there is a consequence to using these words. And since they're probably not going to work under the copyright law anyway, it's really not worth it opening up yourself to that potential liability when there's no value in the words themselves from a copyright perspective. So I would say stay away from these. People say, then the only other thing that I would want to raise is that assignments do have one downside, and that is that assignments can be terminated by the assignor between the 25th and 26th year after the assignment. So this happens from time to time. It happens a good bit in the music industry where things have a very long shelf life and they have been given over by assignment. But it's really not likely to be a big deal in most businesses. And even if it were a big deal and valuable in a given business, the fact is that most people assigning their rights don't even know about the ability to terminate. So I see it as a very low risk. But the bottom line is beware when you see the words work made for hire. I would try to stay away from it in your independent contractor agreements.
So we talked a little bit about registration for copyright. So what is it and why get it? Well, first, it's very easy to get. It's inexpensive. You pay a nominal fee to the Copyright Office and submit your copyright, and then you can get a registration fairly easily. It's required to take action against the infringer, and that's really the critical point. Is if someone's infringing your copyright, you can't do anything about it unless you've registered your copyright for the most part. And having a registration before the infringement begins enables enhanced recovery. So you can't really wait to see if someone's going to infringe and then register. You lose out on a lot of potential damages that you could collect at that point. So we generally recommend that you register fairly regularly, and obviously it's dependent on the type of work. With a book, you register as soon as it's done. With a website, though, you want to register relatively frequently to make sure that you continue to protect new creations and new works as you post them up.
And that's the kind of thing we can talk to you about. If you have a product that gets updated regularly, a software product, for example, or a blog or something like that you do want to protect, but that changes regularly, we can talk about what kind of schedule makes sense. Ashley noted the nominal fee. It's $45 right now. So each time you wanted to register a new version, it's another $45. Obviously, if you were registering it daily, that could get very expensive, adds up quickly. But to the extent that it makes sense to do it monthly or even quarterly, it can be a much more manageable expense that really makes sense for the given product. But we're happy to talk to you more about that. And then the question I get a lot about copyright is, what about the copyright notice? And the bottom line is it's not required. You don't have to have a copyright notice on your work in order for it to be protected by copyright, but it does have benefits. The main one technically is that somebody can't claim that they didn't know you were claiming copyright in a given work or that it's otherwise protected if it has the copyright notice on it. So it removes what's called the innocent infringer defense, although that defense is very hard to raise at any rate, but it does eliminate that defense. But moreover, it just basically has a psychological effect. People see more value, people see it as protected, people see it as important if it has the copyright notice on it. And here's the format for the notice. That last section, all rights reserved, really has no effect whatsoever. It's a vestige from a long ago trademark agreement, worldwide trademark agreement, a copyright treaty between various countries. But that has passed and it doesn't have any effect in the United States. But because people have come to expect it, it's worth putting it there, just because if you don't include it, people may think, because they're used to seeing it, that you're actually not claiming something that you can otherwise claim. And so I generally recommend including all rights reserved in your copyright notice.
So talking about infringement, and a lot of this is stuff we've covered to a certain extent already, but infringement is essentially unauthorized use of your creative work. And so in order to address it, you want to make sure you have a registration and that you register your work. And liability can be significant. Anyone who is found liable for infringement may be required to pay actual damages, punitive damages, and attorney's fees. And the cost of defending a suit alone can be prohibitive enough to disincentivize people from taking action that's infringing. And another thing that's important to bring up is the new copyright court. For a lot of people who are publishing creative works but may not be major publishers, it may not be worthwhile to, file a lawsuit every time someone infringes on your content. But the new copyright court is making it a little easier. It's recently established, and essentially it allows you to file a much smaller, more straightforward suit it's for claims that are smaller claims. It's essentially a small claims court for copyright disputes.
So what are some examples of infringing acts? Well, there's classic unauthorized use of things, and that's important because it's not just things that are stolen. It's not only where somebody goes in and hacks into your system and takes things. You might have given somebody a license to use something or a permission to use something for certain purposes, but not for other purposes. So a classic one would be images that are taken and put in a presentation that somebody is giving. Well, we're careful about that kind of thing. We happen to be in this business, so we only take things that we have permission to use for these type of products. But it's very common for people putting something together to just go on the internet, screenshot something, and drop it into whatever it is their product that they're creating. So that's something to be aware of. That would amount to infringement in many cases unless you have permission to do so. Another example would be unlicensed copies of software. So you purchase software saying that it's going to be used on one machine, and instead it's copied onto multiple machines. Less likely now when things are downloaded by machine, but when things were distributed by disk and the like, or CD-ROM, it was much more of a problem. And it led to a lot of liability for a lot of companies over the years. The other one that I do want to make a quick mention of is open source code, and we'll talk about this later. But if you use open source code, which is generally permissible, you just have to make sure you're doing it within the permission that you're granted. And I'll talk more about that later. And then the final one I want to note is just user-generated content. And that is that you have to be careful, because if you have a website that allows others to post materials on your website, even comments or the like, that the users that are generating things that are posting things could post things that are actually infringing somebody else's copyright. Just imagine them putting up a picture or something like that, that they don't have permission to use. Your website actually is hosting that and is displaying it, which is one of those copyright rights, and therefore you could be liable for infringement. We'll talk about how to avoid that, but I just want you to keep that user-generated content issue in mind.
So kind of to recap a lot of this, there are several ways you can avoid infringement. One is through assignments. You can have work assigned to you so that you then have the right to use it. You can license a work so that you have the right to use it, even if you don't own it. You can use work that's in the public domain. So classic example would be the Bible. You can post anything you want from the Bible and nobody owns it. DMCA, which is the Digital Millennium Copyright Act, has a number of safe harbors in it. Particularly, we talked a little bit about this with the user-generated content, but particularly for companies that operate a platform that allow other people to post. As long as you take action to address infringing content that's posted there, you're unlikely to be liable just because something was posted on your site. And fair use is the final one, and address this a little bit, but so everyone's a little bit familiar with the fair use doctrine. So looking at this poll, which of the following do you think is permissible under the fair use doctrine? Copy and pasting an entire article on your Facebook page, quoting a full paragraph of a book in an article critiquing it, or using another software program's code to make a different program? Or none of the above? All right, we have a few answers in here. Yeah, so, and that's generally going to be right, is quoting a paragraph in an article critiquing it where you're not claiming that work as your own and you're clearly offering a critique or commentary, is generally going to be okay. And of course, there are some variables depending on how much you're using and in what context and whether or not you're obtaining income. So you really want to be careful whenever you're claiming fair use. Now, while that's likely to qualify as fair use, of course, as I just said, there's a number of variables that could affect whether it actually qualifies. So you always want to be careful when you're doing something and relying on fair use, because you're likely to face some liability or at least some cost for defending a claim against you. And so you want to be really careful and judicious about relying on fair use.
And finally, in copyright, I just want to touch on this open source issue or copyleft. You also hear that. Just be clear that this is not the same as public domain. You don't get to do anything you want with these materials that are released under an open source license or are labeled as copyleft. The bottom line is these are licensed materials. It's just that the license says you don't have to pay anything for them. It does, these licenses do have other terms. They could have a requirement of attribution, so you have to identify the owner of the given work, or they could contain something commonly that says something to the effect of, you can use this, but anything that you use it in has to be similarly released under this same kind of license. And so you have to be careful about these. If you're grabbing something that is labeled as open source or copyleft, just make sure you understand the terms of the license that you're taking and that you comply with those terms. And that's going to wrap it up on copyright, and we'll move on to patent.
So first, I just want to, include the caveat that neither Nate nor I are patent prosecutors, so we don't prosecute patent applications, but we have worked with them a little bit in litigation context and in other contexts, so we can definitely provide you some general principles about them. So what is a patent? A patent covers novel, non-obvious, useful, and adequately disclosed inventions. So novel means it's something that must differ from existing public information. You can't just take something that's out there and then patent it because no one else has. It's got to be something new and that you've essentially created or come up with. Non-obvious is again, that kind of goes off the novel point, but it's got to be something that the average Joe couldn't just stumble across, something that is beyond the ordinary abilities of someone who's skilled in the relevant field. And then useful, it's got to be something that actually has some utility, functional purpose. It can't just be something that you just happen to invent by chance and you think it's cool. And it's got to be adequately disclosed. And this is one of the things that people weigh when they're determining whether or not to file a patent, because when you are filing the patent, you are essentially telling everyone, here's what I've invented, here's how it works, here's how you make it, but you're obtaining rights to prevent other people from doing so. So a few examples of cannabis-related patents, and this is a little bit different than trademarks, where we talked about how federal law restricted your ability to trademark cannabis products. A few of you asked about the enforceability of cannabis products or cannabis patents, and they are enforceable. The patent office is pretty, doesn't have a whole lot of moral qualms about giving exclusive rights to cannabis inventors. So these are all things that have been patented at the federal level that include mention of cannabis in their patents or are cannabis themselves. So you see in the bottom right, there is a unique strain of cannabis that someone invented using botanical skills that I do not have, so can't describe in detail, but basically it invented a plant that has a stronger has more THC than other cannabis plants. And they have patented it and now have the right to protect it and prevent other people from growing that plant without their consent. Then you see a device on the left, which is a device that's for stripping buds, leaves, and seeds from a plant. Could be cannabis, could be other plants. That is, again, a valid patent. Top left, there's a process for generating hemp oil with a high cannabidiol CBD content. Again, that's something that, based on the trademark office's standards, probably wouldn't be allowed, but the patent office is very happy to have it patented. So that is something that's protected. And on the top right, you see something that you might recognize. So that is a vaporizer device, which is and the registration for that is currently owned by Juul Labs, which many people have heard of. Their patent lists, among other things that could be used in the vaporizer device, it lists cannabis as a potential use for that. So those are all patents, and you can get a valid patent at the federal level for any number of cannabis products. So,
go ahead, Ashley.
So who owns a patent? It's generally going to be the inventor. their employer, again, with some caveats that Nate will discuss, and or an assignee.
The bottom line is that in the employer situation, there is work for hire is an understood term under patent law. It's just a narrow scope. It has to be that you've employed the person to invent that given work, to specifically work on that given work. So you just have to be careful with that. And as you may have experience with, often when you're joining a company, the company will give you an inventions agreement that you sign at the beginning, just to make it very clear that anything that you create either amounts to that work for hire or is assigned to the company, to make sure they dot their I's and cross their T's. And this, when it's an employee, they're not worried about that benefit situation that we talked about under copyright law. And this is different under patent law, but the bottom line is the belt and suspenders is commonly used here.
So when you're filing a patent application, you have to file it within 1 year after your invention has been published. So, you can publish your study saying we've discovered this, but if you don't file it within a year, you lose it, it becomes public information, and then you can't patent it. Generally, as we said, the inventor is the one who has the right to the patent. But it's best to file it first because it'll, from a proof point, it's a lot easier to prove that you invented it if you're the first one to file it. Second of all, it just streamlines the process and makes it a lot simpler. You avoid a lot of other people contesting your rights if you're the first one to file. But if you can see from this diagram, B conceives it, then A conceives it, A files, then B files. As long as B filed within that year, B still is going to have the superior rights to the patent. It's just going to be a lot more of a hassle, and they're going to have to do a lot more work to show that they were the first one to conceive and invent it.
And from a practical perspective, they're going to end up spending a lot more money than they would have otherwise had to spend. And speaking of the money, what does it take in connection with the patent? Ashley has some information on that.
So this is one of the things that prevents a lot of people from getting a patent. And I know one of you raised this prior to this presentation, is it costs a lot of money to do, and it's not a guaranteed thing. It takes 3 to 5 years generally to obtain a patent, and $20,000 to $40,000 to prosecute. And of course, that cost can be driven way up if people start contesting your rights. So one of you asked about how to avoid a wild goose chase, and there's if you're gonna try to prosecute a patent that you're not going to obtain, and there are a lot of things you can do to ensure your patent prosecution is strong, which again we don't really address, but it's one of the things to consider when you're deciding whether or not a patent is worth it, is worth prosecuting, is whether or not you're really sure you're going to succeed and whether or not you have this money to spend.
And in that realm, usually in connection with patents, you're dealing with science, you're dealing with scientists. Very few scientists build anything without standing on the shoulders of giants, as it said. And so the scientists generally know what else is out there in the industry. And so it's less likely that you're running down these goose chases, if you will. That said, you could understand there could be people, take plant strains, for example, working on very similar things at the same time, not knowing about each other. Well, that's kind of a risk of the trade. There's no question about it. You can't eliminate that risk. You just need to move as quickly as possible, focusing on your specific product, your specific invention, and making sure you get that not only reduced to practice, that is, you finalize the product, but also you get that application in quickly in order to make your rights as strong as possible and to avoid as many hiccups as possible that could result from delay. Not only is patent expensive to pursue, but it also can be expensive to protect. First of all, if somebody infringes your patent, you have a number of remedies. Probably the most important one is that you get to stop them from infringing the patent, that is the injunction, but you will also get at least reasonable royalties and possibly your lost profits that arose from their infringement of the patent. Additionally, if they were willful about it, if you show evidence that they knew about you and went forward nonetheless, you can get up to 3 times, that is treble damages. So it can be very worthwhile to take action. That said, what does it take to enforce your rights in a patent? Well, patent suits on average go for about 1 to 4 years. So nothing is immediate. And while you're litigating, it takes a lot of your attention, a lot of your company's attention. And so that attention is not being spent on the business itself. So there's certainly a cost to that. And then as far as specific costs, patent cases are averaging about $6 million in expenses. So they're not for the faint of heart. Now, those numbers are definitely skewed because of, I'm sure you've heard a lot about Apple's patent litigation and things like that are, just on a different level and driving things up. But even taking that into account, patent litigation is very expensive. So it's not necessarily something you want to jump into. So when you couple the expense of enforcement along with the expense of getting the patent in the first place, are there other options? And the answer is yes, there are. And we're going to talk about that next. And it's not one size fits all. It's not the trade secret that we'll talk about is always better, but there are advantages to trade secret protection. And it certainly is likely to be a more economical type of protection. So let's talk a little bit about trade secrets.
So what is a trade secret? A trade secret is, at the most fundamental level, a secret. It is something that it's generally protected under federal and state law. Most states have statutes protecting them, and federal law does too. It's information that derives independent economic value from not being generally known. So something where its secrecy is one of the things that makes it valuable. And is the subject of reasonable efforts to maintain the secrecy or to maintain its secrecy. One of you had asked about protecting synthesized compounds, and this is something that could easily fall into that category if it weren't novel enough to be worth patenting. It's still something that even if other people have done it, even if it's been done in other contexts, the fact that it's not generally known throughout the industry and is something that you've worked to keep secret, something that might make it qualify for trade secret protection.
So how do you go about getting this trade secret protection? Well, as you've heard Ashley say a couple times now, and I'll continue to say it, the key is keeping it secret. In order to be protected as a trade secret, it has to be secret. So what do? You want to, first of all, identify your given trade secret and note that you're protecting it, make in your own files, make it clear to your company that you're protecting it. And then you want to limit the accessibility to that to those who need to know. So you don't want to just allow anybody in your company to have access to your trade secrets, only those that will need to use those trade secrets, to use the information that you're protecting in connection with the company. Additionally, with vendors or third parties or investors, you may have to disclose the information to those people because you want them to understand how to use it or why it's important to your business or why it makes your business valuable, but you have to do so under protections. So again, those who need to know, and you want protections in contracts. So with employees, that tends to be confidentiality agreements that are in place. And in connection with third parties that you're disclosing information to, you want to do so in connection with non-disclosure agreements that limits what those third parties can do with that knowledge that you're letting them have. Basically, that makes that secret a little less secret. You want to control that secret using agreements. So what happens when a trade secret is breached? That is, how is it misappropriated? Well, it can be through criminal theft, as in connection with hacking, or if somebody broke into your offices and stole physical files that included the trade secret information. But it could just be not even anything illegal, just something that amounts to an unauthorized taking. So something that breaches that confidentiality agreement or that non-disclosure agreement. The bottom line is that any taking of your trade secret through unauthorized means, whether illegal or not, would amount to a misappropriation of your trade secret that could be actionable, that you could take action in court against them. So trade secret litigation has a lot in common with patent litigation, and it's not cheap as with any litigation. But again, you're saving a lot of money up front. And there could be, as Ashley said, some things that aren't quite reaching the level of patentability, but that could be protected through trade secret. The other thing about it is, as Ashley noted earlier, you can register a patent, but in order to do so, you have to disclose your invention. And so your rights and your protection will only last as long as the patent, which is about 20 years. Whereas with the trade secret, as long as it's kept secret, it can go on forever. And the classic example of that is the Coke formula. That is a trade secret of the Coca-Cola company. And they work very hard to protect it. And it still hasn't been disclosed after 100+ years. The other thing I want to raise about trade secrets is, as compared to patents, is that your trade secret only protects you against those who take from you. If somebody independently discovers the same thing and never had access to any of your secret information, you would not have a claim against that person. Similarly, if they took your product and they reverse engineered it and took it apart and see how it works and made their own based on that, that's basically them figuring out your secret, not breaching anything in order to get to your secret, but instead figuring it out. And that's permitted under trade secret law. Both of those situations would be actionable under patent law. So patent gives you stronger rights in some senses and certainly has significant value. So again, it's not a one size fits all. Trade secret is certainly more economical at the outset, but it doesn't mean it's always right for every situation, and it has to be considered. And so with that, we're going to finish up, and it's been our pleasure speaking with you.